ready to be seated. All right, ladies and gentlemen, we will now proceed, the state will proceed with rebuttal case. Thank you.
Good afternoon again. I know it's been a long day. I'm going to try to confine my remarks simply to responding to some of the things that the defense team has put forward. First and foremost, I want to say this. It is not the mission of prosecutors like Mr. Borst and myself to label anyone as a criminal. My job, as I told you at the beginning of this trial in jury selection, is to present evidence. And I am organized, and so is Mr. Borst. And that's why we were able to introduce into evidence more than 100 items for your consideration. Videos, photographs, body-worn camera recordings, written documents, court pleadings, copies of receipts from the point at Ocean Reef Club. We're organized because we have a mission, which is to present the evidence for you, the jury, to consider. It is not our job to ask you to make your consideration out of sympathy. And I will tell you in no uncertain terms, if Mr. Borst and I did not prove the charges of vessel homicide and or manslaughter, and you decide to find him guilty because you feel bad for this girl, you will tarnish her memory. Because your verdict would be a miscarriage of justice were you to convict this defendant if the evidence does not support the conviction. But likewise, I'm not coming to you asking you, oh, poor Lucy, he's a monster. No, I'm not doing that because that's not my job. That's not professional. But at the end of defense counsel's summation to you all, he was basically asking you to have sympathy for this defendant. Look, we're all human, but your verdict cannot be based on sympathy for anyone in this case. It has to be based on the facts. Counsel saying, oh, maybe he was thinking about how lucky he is or how much he loved his wife or whatever. You know what that's called? That's called speculation. The judge is going to give you an instruction about what reasonable doubt is. It's not an imaginary, forced, or speculative doubt. What was in the defendant's heart and mind when he smashed into that channel marker is irrelevant. What's relevant for your consideration is what is the evidence. So let's talk about that evidence. The defense takes one word, inattentive, and says that's what I base my whole case on. And that's just not true. And I'll tell you why. This case is based on so many failures on this defendant to operate in a safe, prudent, and reasonable way that any one thing by itself, well, human, you can make a mistake. But when you heap mistake after mistake after mistake on him, when he was the one at the helm, when he was the one calling the shots, where they go, how fast they go, then we know. First off, we've got him with 12 teenagers, 10 of whom are on the bow of that vessel, leading to at least 1,000 extra pounds, which if you remember Mr. Albert's testimony, remember he had that bright green boat, and he showed you how the extra weight on the bow of the vessel is going to make it harder for it to operate on a plane, so you're going to be going faster, and the faster you go and the more weight you have on the boat, guess what? The harder it is to navigate it. So that's another problem that we have. This vessel becomes less responsive because of the weight and the speed. Let's take another factor into account. The fact that he had a bunch of teenagers who'd been drinking the alcohol that he provided. How does that factor into recklessness? It factors in because you now are responsible for the lives of minors, but not minors that are operating at the peak of clarity, minors that have consumed alcohol. And some of them, a lot of alcohol. You're responsible for the people on your boat. So you darn well be driving carefully to get them safely back to the party you're waiting for. But what else? The fact that he'd been drinking too. That's a factor. I'm not here to prove that he was BUI. I'm here to tell you that this is yet another knock against the safe operation of a vessel. The fact that none of these girls were wearing life jackets, the fact that he wasn't wearing a kill switch, did those cause him to crash into that channel marker? No. But if you're being a safe and prudent operator of a vessel, if you are taking your responsibility seriously, then if you know that they've been out drinking, if you know you've been drinking, it's reasonably foreseeable that maybe everybody's not at their top of their game. Maybe it's likely that people could maybe not have their best judgment. So you know what you do when you're a safe and prudent operator of a vessel? You tell the kids, put on life jackets. And you wear a kill switch. Because if something were to happen, and those engines keep spinning, which we know they did from that last track mark that Mr. Albert showed us. Remember the little curve? You see all those little track marks. Those engines were still going, thank God. Thank God nobody got chopped up, okay? But that's another factor for you to consider. Here's another one. We know from the specifications of that boat, he was going full throttle. Just because that Robalo is rated that it could go as fast as 55 miles an hour doesn't mean that it's safe. I think I've seen a lot of cars that have speedometers that go past 100 miles per hour. Just because you can do something doesn't mean that it's safe and prudent to do it. Imagine operating a car. A driver puts the pedal to the metal and makes that car go as fast as it can. That's what this defendant did with a boat full of kids. What else makes this reckless? What else makes this criminally negligent? He knows exactly what channel marker 15 is. First off, he'd gone past it earlier that very day to get up to the sandbar. But beyond that, you saw the track marks that were left from his boat time and time again of him going from Ocean Reef to that sandbar. He knows that that channel marker is there. But he pays no attention. What else takes us into the recklessness? There's no reason for him to have crashed into that channel marker. There was no wind, the seas were calm, and it's daylight. What else makes him reckless? What else makes him criminally negligent? He's on the wrong side of the channel. Did that in and of itself cause the crash? No, but when you think about the rules of the road say you operate on the right-hand side of the channel. If he's operating on the wrong side of the channel, especially during a Labor Day weekend when you have more vessel traffic, if there is another boat, had there actually been a phantom boat, right? Where's that boat going to go? It can't go outside the channel if it's big, because it's going to run aground on the shallow waters of Biscayne Bay. That's a hazard. So all of these things, not just the 9 seconds, but I want to really emphasize, the defense talks to you about the fact that, oh, maybe it was just a couple of seconds. No, it's not just a couple of seconds. I can't stress this enough. This is how long he was headlong toward that channel marker that he knew was there when he'd been drinking with a boat full of kids, with a vessel that's overloaded with weight for that speed, when he's going full throttle and on the wrong side of the channel. This is how long he is checked out, ready, set, go. That's a long time. Nine seconds. That's more than enough time to check your GPS screen. That's more than enough time to see if any other boats are coming around. That's more than enough time to even, if you want to glance at your wife's cell phone. That's a long time to be heading straight into a steel pole with a gigantic day-glow green sign on the top of it that you know is there. So it's not just, a few seconds of inattention. It's everything together. You have to consider all the factors that were at play, all the things that had to happen for him to wind up hitting that channel marker. And, as to the defense attorney's point that, but if he only would have just gone a little more in this direction or this direction, he wouldn't have hit the channel marker. Okay, let's think about this. Let's think about somebody that goes skydiving, maybe has a parachute on. Splat! Right on the ground. Well, gosh, if only he would have pulled the ripcord, he'd be okay. But that's the kind of argument that you're giving. That doesn't make sense. And the law makes sense. The law can't be such that a person can be that inattentive, can be that checked out, zoned out, spaced out, whatever you want to call it, that you are utterly unaware of your circumstances. You are not taking into account the safety of your own passengers. The law can't abide by that. It's not about labeling anybody a criminal or a bad guy or a good guy. It's about evaluating the conduct and applying the law. And along those lines, I just want to say that to give you an idea of just how much all of these different factors really count in a case like this, I have this rope. And if you look at rope, which ironically for a nautical case, I guess, but if you look at rope, there are many little individual strands, none of which by itself would be strong enough to hold on to an anchor or that one boat can tie up to another, okay? But what happens when you take all the little strands of the rope and you start intertwining them and you weave them together, those little strands, when you put them all together, become very strong. And that's why the evidence in this case is very strong for the fact that he was operating his vessel recklessly, and that because of all those other factors, which I already covered when I spoke with you initially, not just reckless. Reckless is the baseline for this conduct. More than reckless. Culpable negligence, manslaughter. To the extent that defense counsel says he never wanted his daughter or his wife or those kids to get hurt, of course. Who would say otherwise? If I had the proof that he deliberately tried to kill somebody, the charges would be different. But just because you don't have an evil heart or you don't have an evil intention, it doesn't mean that you are immune from the laws of this state. If you, even without an evil heart, engage in a course of conduct that is clearly this dangerous and that clearly could have such devastating consequences, then you're properly charged with vessel homicide and manslaughter. Now, I had a feeling that we were going to hear from the defense things like, there's no requirement to wear life jackets. There's no speed limit. There's no requirement for a kill switch. There's no proof beyond a reasonable doubt that the defendant was impaired by alcohol. There's no proof that expired flares don't work. Of course, none of those things individually caused this crash. But again, with the rope scenario, these are just more factors to take into account. Not wearing the kill switch, not having the kids in a life jacket, that you had been consuming alcohol, that you are going as fast as you can. And to say that there's no speed limit on the water, that's not true. There is. The speed limit is set by navigational rule number 5, which Mr. Albert told you about. Pardon me, 6. You have to go at a safe speed for the conditions. It's not the same as being on the land, obviously. We have 55-mile-an-hour speed limits, sometimes 60 miles an hour speed limits. Through school zones, we have 15-mile-per-hour speed limits. But on the water, the rules can't be rigid the way they are on land because the water is a whole different environment. This was a flagrant foul, if we're talking NBA. The defense attorney says, oh, the prosecutor, she tells you all this about Lucy's injuries. And I do. But not really so much to tug at your heartstrings, because I'm telling you, it would not be a lawful verdict for you to find the defendant guilty just because you feel sad about Lucy or the injuries she had, or you feel sad for her family. That's not what we're here for you to do. But you understanding those injuries was a necessary component of this case. Because you know what? You don't go so fast. Your boat doesn't smash into the channel marker so hard. Your boat doesn't wind up being basically severed from stem to stern. Your boat doesn't start taking on water to the point where it flips upside down and traps a young woman who had her head bashed. You heard from Dr. Garavan, our Irish medical examiner. He talked to you about the fact that the injuries that she had are consistent with her hitting her head and then her head jerking back, which is why she had that deep bruising in the back part of her neck. And that could cause her to become unconscious. And her now being trapped under that boat, which, like I said earlier, basically became her gravesite. Her being trapped is what caused her to die. So that's why you needed to understand those injuries, because you know what? You slow down, your boat doesn't hit so hard. Your passengers don't get conked in the head to the point where they're rendered unconscious. You don't wind up unconscious. If you just slow down, operate your vessel safely. He didn't want to do that day. He clearly knew how to. People trusted him. People trusted that he would take their children out to that sandbar and be safe. So he knew how to operate safely. He simply chose not to. The defense attorney talked about alcohol. Oh, everybody was drinking. Okay, well, first off, just because everybody's doing it, A, doesn't make it right. And B, the only people who testified from the boat about whether or not the defendant looked impaired were themselves drinking alcohol. We had the defendant's wife takes the stand, and, she acknowledged, yeah, she was drinking Chambord and Prosecco from one of those Yeti tumblers. She says, yes, I was drinking. But what was kind of funny is that in court, she said 1 or 2 drinks. But in her interrogatory, if you remember when I read that to you, and you'll be able to look at it for yourself, in her interrogatory, she said she had 2 drinks. How come she all of a sudden now, oh, I only had 1 or 2? But on her interrogatory, she had 2. And maybe 1 drink here or there, but come on. Prosecco and Chambord. She remembered, but she wanted to undercut how much alcohol she had consumed. So we think that this woman is in a state to really make a good judgment about whether or not her husband should be piloting that boat. Do we think that Cammie, with the 10, alcoholic drinks in her system, is a good judge of that? Caro had been drinking? All these girls have been drinking. They were not the ones to be in a position to make an assessment if he's capable of operating a boat. They're there as kids to have fun at a birthday party. Don't divest your own responsibility onto underage kids that you gave alcohol to. That's what the defense has tried to do regarding that alcohol. It's not a DUI case, but the alcohol can't be ignored. Here's the hatch. You all saw this boat. Here's what it looked like when the police opened it up. And then the police lined up a lot of those alcohol containers that they found from inside. Am I saying that this defendant drank all of them? No. Can I say that the girls drank all of this alcohol? No. But this photograph, States 109 in evidence, tells a story about how prevalent alcohol use was on that afternoon. And because it was so prevalent, he had a duty to be careful. Not just be beyond negligence, but he was so far beyond the pale. It does cross into recklessness, and it does cross into criminal negligence. At least if the defendant was maybe buzzed or impaired by alcohol, at least there would be some explanation for why he crashed into that channel marker that's so clearly visible. Had too much to drink. At least there's an explanation. You could understand why. Not that just think that it's a good thing, but it's understandable. But let's suppose he did not feel any effects of alcohol whatsoever. Does that then not make him even more reckless and more culpably negligent? Because then what the heck are you doing, buddy? Why do you not see that which is right in front of you? I could almost understand it was alcohol. Again, still not good, not appropriate. But to crash into it if you really were stone cold sober, that's almost worse.
Objection, burden shifting.
The navigational rules are the warning to all voters. Violating navigational rules all by themselves will not land you in a case like this. But when you violate so many navigational rules, you're on the wrong side of the channel, you're going too fast. Nobody says that you have to have somebody serving as a lookout, but man, if you don't have anybody serving as a lookout, you'd better be looking out yourself. And he didn't do that. That's like so fundamental. The navigational rules of taking steps to avoid the risk of a collision. Him traveling on that wrong side of the channel marker 15, clearly the channel marker 15, clearly visible to him. He didn't even abide by that rule. And then, of course, the rule number 8, avoid a collision. He had plenty of time to avoid that collision. He didn't. The defense attorney said to you that it's not fair to his client to say, oh, you shouldn't have had all those girls seated in those seats on the bow of the boat. You know what wasn't fair? It wasn't fair to Lucy and those other girls to operate that boat that fast with that many girls there. Sure, they could sit there, but if you've got that many kids sitting up at the front of your boat, slow down. Don't tell me that it's not fair to him. It wasn't fair to any of those girls, all of whose lives he endangered. Yeah. This is footage from a drone that did in fact follow a vessel. It's following the same path that this defendant operated. Here you can see channel marker 14. Let's rewind a little bit. Channel marker 14, channel marker 15. This is the boat that Detective Dow and his partner, Sergeant Kopp, were on operating the drone. The drone is following the FWC vessel that's trying to recreate as close as possible the path that this defendant took on that day. Closer and closer to number 15. Closer and closer. And it's only because Lieutenant Thompson is a damn good pilot of a vessel that he did not collide with that channel marker. And so to the point where the defense attorney said, oh, if somebody was on a drone and watching Mr. Pino operating his vessel, would they want to stop him and say, what are you doing? Yes. Of course they would, because they'd say, what are you doing? Why are you heading right to that channel marker? The drone tells you. Here we are, right by channel marker 15. Here comes the FWC vessel. Look at that course. Anyone who saw that vessel coming from that distance would say, what are you doing? Are you crazy? Why are you risking your life and the lives of these kids? How can you do that? So let's talk a little bit about these injuries that the defendant had. It's funny how he's just fine to crawl up onto David Rodriguez's boat, but he's so damaged that FWC, oh wait, no, FWC didn't life flight him away. They didn't take him in a helicopter away. They had fast boats that could get him to the mainland. They had the means to take him if he was seriously injured, like they did for other passengers. Not him. He was treated, you have body-worn camera footage from Lieutenant Thompson on the Elliott Key Harbor. You'll see that he's got his head bandaged, yeah, his head's glued. And yeah, you gotta seal the wound. Stitches don't make a lot of sense for heads, so they use staples. But he needed staples, whether it's 3, 7, but the only medical care that he told Dr. Barrett that he had was therapy and some psych meds. And I don't take anything away from somebody seeking mental health care if they've been through a difficult scenario. But that is not the same as somebody that has a head injury so bad that somehow it causes them to create false memories without the intent to deceive. And then when we think about that evidence, false memories without the intent to deceive, let's go back again one more time. And the defense says, oh, like I'm some kind of horrible person because I have the audacity to challenge what a medical doctor says in this courtroom. I challenged her because the testimony that she gave is not credible, but you're the judges of who's credible. But she literally took the stand and she said she based her finding that he had amnesia just on these 4 things. That he didn't remember who sat behind him, that he said his engines were 225 horsepower, that he couldn't remember exactly what happened post-impact, and that at first he said it was Nati, then he said it was Lucy. That's it? You get paid 30 grand for that? She didn't even say that he did confabulate, right? She just said it could have happened. But again, reasonable doubt is not a speculative doubt. What evidence do you have that this is really signs of amnesia? First off, we already talked about the fact that even she testified. Oh, whether or not he could remember exactly who was behind him, she's like, well, that makes sense that he would not remember who was behind him. She said, yeah, you know, after a traumatic event, maybe you don't remember exactly what happened. We already talked about the fact that it would make sense if maybe he was confused about which girl he saved initially, because he wasn't the one that brought that child to the rescue boat. He just ducked under his boat after being told to do so and recovered the body, but then passed it off to someone else. And I don't mean to refer to Lucy as an idiot, but that's what he did. So the one thing that we're left with, the reason why we believe that this defendant gave that whole story about a phantom boat is because he thought that he might have engines of only, 225 horsepower? That's not reasonable. I'm not here to bully anybody, but I'm also not here to allow you to not think about whether or not the expert witness that's called is giving you testimony that you should feel comfortable relying on. The witnesses that I want to, trust me, I'm not going over all of them, but I think it's worth kind of looking at in totality. Look at the officers who were called. Bobby Bruto, Sergeant Delgado, Ben Dow, the drone operator, Detective John Dalton, who's both been a Marine Patrol officer and a vehicular homicide or traffic homicide investigator. You heard from Lieutenant Morris and Lieutenant Thompson. Did any single one of them get caught up in some kind of sense that what they were saying to you, they didn't know what they were talking about? That they had some ulterior motive behind doing this? How about the passengers? Cammie, Caro, Claudia, Natalia. They all come here and say, we were there for a good time. We've known the Pinos for a long time. We felt like we were safe, but, geez, most of these girls are sitting facing backwards. They have no position to know whether or not George Pino is operating his boat safely. What about the Good Samaritans that you heard from? Hillary Candela, who knows everybody involved, called Conti Quaid's dad to say, hey, I'm out here on the water. I think there's been an accident. Hamlet Rodriguez, who takes Lucy's body and gets it to the Good Samaritan vessel. David Rodriguez, a little bit of a, maybe a little bit of a character, because, I don't know a lot of people who come across a man that's stranded with his boat and take time to photograph it, but he did. Okay. I thought it was interesting that the defense showed you that 6-second video that he had of the defendant. But I was like, oh, you got a picture of him too? Well, come on down here. Let's show that picture to the jurors. And I think that when we zoomed in, you could see the defendant not saving anybody, just hanging onto his boat. You heard from a couple of doctors. Dr. Garvin, the medical examiner, and you heard from Dr. Barrett. I'll let you judge who's credible. We heard from some lawyers, Brent Reitman, who was one of the attorneys that represented the Puig family in their lawsuit. Didn't ask him a whole lot, just wanted to make sure you understood what interrogatories were. The defense, I called Mr. Mescalado just to confirm, yes, this is a normal part of the discovery process in a civil case. And that was it. I just had him read the interrogatories. But, when the defense called him back, he starts talking about how Mr. Pino wanted to make everybody whole and all this other stuff. Who cares, right? But it did become relevant that he did try to limit his liability once he makes a statement like that. It did become relevant that he tried to get counts of the lawsuit dismissed. He made it relevant, not me. All I wanted was the interrogatories to come in. But at least he did admit that in answering an interrogatory, it's perfectly fine to say, I don't know. I didn't see the crash. Did Cecilia Pino do that? Nope. Talk about Mr. Albert. Knows his stuff down cold. Not impeached with a single thing. His expertise in GPS data extraction, interpretation, unchallenged. That GPS data that you got is irrefuted. You talk about Andy Fernandez taking the stand at the beginning of this trial and as the very last witness, who, despite having lost his firstborn child, kept it together and answered questions. Can you imagine cross-examining that man and trying to get a oops, gotcha? Because, you weren't planning on going there? Well, don't you remember that client sent a text to you about meeting up at the sandbar a week before? Yeah, and at that time I thought maybe I would. But on that day, I was tired from playing golf and I didn't really need to go all the way out to the sandbar and then come all the way back because I had my plans to go to the football game with my dad. That's the gotcha of the father who lost his 17-year-old child because of the actions of a man that had been his friend? Rudy Puig took the stand. The injuries to his daughter are not really the issue here, but to the extent that something was made by Mr. Mescalado, the defendant's former lawyer, about, the Puigs didn't settle, you deserve to know at least that she's not the same now as she was before this crash.
All right, Councilman Soto.
Thank you, Jackie. Last 2 points I want to make. The defense, in this case, had no burden of proof. The burden of proof fell solely on Mr. Borst and me. Throughout this trial, we've presented you with what I would submit are very compelling witnesses. We've presented you scientific facts, data, that would substantiate a guilty verdict for both vessel homicide, for being reckless, as well as for manslaughter. And so when you go back to the jury room, I'm going to suggest, but it's totally up to you, that you may wish to first look at count 2 of the information, vessel homicide, and that you can make a finding that because the defendant was reckless, even if nobody else was on his boat but his wife, just the direction of travel put him on a collision course, that the verdict would certainly be guilty. But then I would suggest, but it's your call today, that you then consider all these other factors that were at play on that day. These factors didn't have to be there for a vessel homicide conviction, but because they are there, I'm also asking you to return a verdict of guilty as to the manslaughter charge. Because he did do an intentional act by deciding how fast to go and what direction to travel, and that caused Lucy's death. And because the way that he operated that vessel was culpably negligent. And the very last thing I want to say to you is not me speaking to you, it's you watching what happened in this case. Thank you for your time and attention to this travel today.
Thank you. May I see counsel and court reporters? Please everyone, please stay quiet.